people should do in their estate planning by seeing how sometimes things didn't turn out very well after someone died. Now, when we run into an issue after a loved one dies, sometimes we can fix the mistake that was made, but it's usually expensive to do so. Oftentimes, we cannot fix a mistake, it's too late. And so my goal this afternoon is an educational one. I am not here to solicit your business. That's why I just had a handout put in front of you with my name and phone number on it. That was a joke. But in all seriousness, my goal is for you to go back to your lawyer, back to your financial advisor, back to your accountant, and make sure that everything is the way it should be so that you and your loved ones do not experience these problems that we've seen crop up after somebody dies. I am very comfortable with questions. So as we go through this, if there's something that you want to ask a question about, that will not throw me one bit. Just raise your hand. Now, I know it won't be about you. It'll be about your friend or your neighbor. But the best part about this afternoon is there's no bill. So, hey, what a deal. Free lawyer. And I do want all of your questions to be answered. So I will stick around afterwards if you'd rather ask me in person, and that would be just fine. So just like David Letterman, I do 10 down to 1. So the number 10 mistake I know does not apply to anyone in this room, and that is no planning at all. Now, I speak to a lot of groups where I'm being facetious when I say that, because I know that most Americans have not done planning. With the Parkinson's Family Support Group, I would be surprised if the majority of you did not have planning in place because of what you're facing with you or your loved one. But the fact of the matter is most Americans don't get around to doing estate planning, and that has unintended consequences that sometimes are not what the person wanted. You see, at a base level, a proper estate plan makes sure that your property goes where you want it to go when you die, and that the people that you want to be in charge are named. Sounds simple, but the devil's in the details. Let me give you a couple of examples of mistakes in this regard that I see all the time. We'll use the quintessential Nebraska example of a farm. Let's say that I inherited a farm from my parents and it was just in my name. There's that rain we need. Isn't that wonderful? I love it. By the way, last night we had some really close friends from Hastings, Nebraska come in, and they stayed with us last night because they went to the Zach Bryan concert at Memorial Stadium last night. So they went down. They thought they were going to tailgate for an hour. They tailgated for 4 hours because the concert didn't start till 10:30. And they didn't get back to our house until 1:30 in the morning. And they left when there were still a couple songs left. And they still got up and went to church with us this morning. So that was pretty cool. But I think they're going to have a nice nap this afternoon. So let's say I inherited a farm and it's just in my name. And then I did not have a will in this example. Now, you better believe I have a will and a trust. I better, right, as an estate planning lawyer. But in this example, let's say I inherited a farm, it's in my name, and I die. You might think that that farm would automatically go to my wife, Ann, of 30 years this year, but you would be wrong. Under Nebraska law, since I didn't have a will in this example, half of the farm goes to my wife and half goes to our 2 adult children, Kristen and John, who are 26 and 24. Our daughter, Kristen, is a first-year law student at Tulane in New Orleans, and she's married to a nice young man from Texas. And I don't think she's coming back. I think they're going to go to Houston after law school. Our son, John, is 24, and he's a financial advisor in Omaha. He's getting married to a nice young lady from Omaha this November. So we've got them both launched. My wife and I are empty nesters, and it's super fun. We're enjoying it. But let's carry that example a step further. Let's say I inherited the farm, and this time I am in a second marriage. I'm not, by the way. I'm in a one-and-done marriage. But in this example, let's say I'm in a second marriage, and this time I did get a will, And I went to the local attorney and I said, you know, I love my second wife. I want her to have the house that we have together and maybe some accounts. But that farm that I inherited from my parents, I want that to go to my kids, my parents' grandkids. And so in my will, I said the farm goes to my kids, but my second wife gets my house. And then in this example, we did not sign a prenup, and I die before my second wife. Well, guess what? If my wife wants to, within 9 months of my death, she can elect and take the first 100,000 plus 1/2 of our joint estate. And if that Nebraska farm ground is worth more than half of our estate, which for our clients who own Nebraska farm ground, it often is because of the value of land. Isn't it amazing? If you don't know, since I graduated from law school in 1998, farm ground in Nebraska has quadrupled, not doubled. When I graduated from law school, a good farm sale in southeast Nebraska would be $2,500 or $2,800 an acre. And fast forward to 2026, that's $10,000 to $15,000 an acre. We had a farm sell out of an estate last year in Hamilton County for $17,000 an acre. Folks, the average farm in Nebraska is 960 acres. So that means in central Nebraska, the average farm is worth $10 to $15 million if you haven't kept up with land prices. So for a lot of our clients who have inherited farm ground, it is by far the most valuable asset in their estate. And most people don't know about this elective share. Frankly, most lawyers don't know about the right of a spouse to inherit half. And increasingly, because of the value of farm ground, we've got 3 of them going in our office right now. We're seeing spouses elect or take. And the bottom line is it does not matter what the will said. So in my example, the will said the land goes to my kids. Doesn't matter if I was married and she wants half, she's going to get half. The only way to avoid that is through a prenuptial agreement where you waive those rights to an inheritance. So these are just 2 examples of how not doing planning can lead to unintended consequences. So don't let that be you. The time to do planning is now. Okay, the number 9 mistake. I have these memorized. I just got to make sure. I've been giving the same talk a long time. Oh, Siri said she didn't get that. Some of you have heard me give this talk before, but I promise it's different every time. And I have been given the same talk for about 20 years. Both my dad and brother are ministers, and they tease me. They say, you know what? We have to come up with original material every Sunday morning, and you can just give the same talk over and over again. You make a lot more money than we do. So I'm like, oh, that's true. Okay, so mistake number 9 is waiting until the last minute to plan. Now, this is a biggie. This was driven home to me during the pandemic. In March of 2020, when the world shut down, our phones rang off the hook. Estate planning was an area that, like some businesses, doubled or tripled because everyone was calling us that had put off estate planning, whether they were people that had worked with us that hadn't got back to us, or they're people that just had never gotten around to doing it. It was not a fun time. We had to see people sign the documents, which meant drive-by signings. I would be at assisted living facilities staring through the window. Mary, is that you? Yeah, I can see. Okay, you can sign the document now. Not fun. And there were 2 reasons why it was impressed upon me that this is not something that you should put off until the end. You know, in our high volume estate planning practice at our law firm, it's about once or twice a month that we get a call from a client or a prospective client who has been given a bad diagnosis. They know that the end is near and they need help right away. And you can bet they go right to the top of our list. Sometimes the staff attorney's headed to the hospital or the assisted living or rehab center that day. Maybe we're coming back that day to sign documents. Folks, that is the wrong time to do estate planning for 2 reasons. Number 1, when I walk into that room at Southlake, I have to determine that this client has mental capacity. Now, I've lived in Lincoln for 40 years, and a lot of people that I work with, I've known since I went to East High with their kids or we went to church together. And when I walk into a room and I look at someone I've gone to church with for 40 years, and she looks at me and says, "Who are you?" And then she turns to her son and said, "Who's this guy?" I know that we're not doing anything. It's too late. I've made some families mad who I know well because they're like, "Well, you know what mom would want. You know, you talked to her a couple years ago at church and she said this is what she wanted." And I said, that doesn't count because she doesn't know who you are or me, and she does not have the capacity to sign a document. So it's too late. There's a time when it's too late before you die, and that's if you no longer have mental capacity. The much bigger issue to put this off to the end is undue influence. This is the biggie. So I'll share with you almost always when I walk into that room at Tabitha and there's mom in the bed, who's sitting in the chair right next to mom? Almost always. Adult child, almost always. And I say, "Well, mom, I hear that you'd like to make a change to your will. What would you like to do?" And the answer doesn't come back from mom. It comes from the adult child who says, "That's right, Andrew. Mom does want to change her will. You see, I'm the healthcare power of attorney. I take mom to all of her appointments, and she would like to leave me a little bit more than my brother or sister." "Oh, really? Okay." So it's at that point that I have to politely excuse the adult child from the room, usually somebody my own age. That doesn't go over very well with mom or her sometimes. Now, most of the time, everything's fine, but you would not be surprised to learn that about a fourth of the time, mom says, "Andrew, thank you. You see, I don't want to change my estate plan, but I'm feeling pressured. You know, I couldn't live at home anymore if it wasn't for my daughter, and she's thinking that I should leave her more." And I say, "Mom, we're not going to do what your daughter wants. We're going to do what you want because this is your estate plan." So we have to be very attuned with undue influence, usually an adult child. And I will tell you, as someone who works with lots of chronologically mature people, how's that? Pretty good. I know that I have a lot of clients who have full mental capacity, but if I meet with mom with her son on Monday, and I meet with mom with her daughter on Thursday, she will tell me the exact opposite answer to my questions because she wants to please the adult child in the room. We're trained to know that undue influence. So my point here is don't let that be you. So the time to do estate planning is now, before someone can convince you to do something you wouldn't, and while you still have your full faculties. Mistake number 8, failure to update. Every 3, 6, 10 years at the most, you should dust off those documents and say, has something changed? Think about your own situation. Think about 10 years ago, the year 2016. Wow, how much has changed in your life in the last 10 years? I bet you've had a loved one pass away. Maybe you've had a child or grandchild get married. Maybe you've had a niece or nephew get divorced. Maybe you inherited property that you didn't have before, which changes the look of your estate plan. All of these are reasons to get back to the financial advisor, accountant, or lawyer. And even if you're not going to change the documents, to see if there's been any updates in the law that might necessitate or it'd be advisable to have a new document. As a law firm that handles hundreds of estate administrations a year, on average, we handle about 300 estates, meaning someone who died every year. I can tell you that about a third of the time, somebody named in the will or trust is either dead or does not have the capacity to serve. You named your sister 30 years ago as your executor when she was in her late 50s. Now she's in her late 80s and she can no longer physically serve as the trustee, but you haven't updated your plan. Who you name, I'll get to that later, is the most important decision. And so especially if it's somebody who would have difficulty carrying out because of the passage of time, that is a reason alone to update your estate plan. Now, we've had significant changes in the law over the last 25 years as it relates to the estate and gift tax. So let me talk a little bit about that, because that's the number one reason over the last 20 years that people have updated their documents. Let me explain how the estate and gift tax works. I think most of us know that we can give as many people as we want a certain dollar amount every year without us, the person giving the money, paying taxes, and without the person receiving it paying taxes. I think we all know that. It's been kind of drilled into us. This year, that's $20,000. So I could give everyone in this room $20,000 and I would not pay taxes on it and you would not pay taxes on it. Many of our high net worth clients every year give $20,000 to each child. An ultra high net worth client gives $20,000 to each daughter and son-in-law to decrease the size of their estate. So I think most people know about that. And I hear all the time, oh, I can't give more than that because I might get taxed on it. Well, probably not. Let me tell you the Paul Harvey on this one, okay? The rest of the story. What's the rest of the story? If you've never given anyone more than the annual amount in any given year, you still have your lifetime exclusion to give away when you die. When I graduated from the Nebraska College of Law in 1998, the annual amount was $4,000 and the lifetime exclusion was $640,000. It's easy for me to remember that because I studied that for the bar exam. And people were rightfully so concerned about the death tax, as they called it, because it was 55% after that $640,000. So you throw a Nebraska farm in there, a retirement account from a professor at the University of Nebraska, you're way over 25 years ago, $640,000. And so people were, again, rightfully so concerned. Well, let's fast forward and update you on significant changes in the law happening in 2001, 2011, 2013, 2017, and 2024. I will spare you the details, but the bottom line is every American can now, at death, give away $15 million. That exemption is indexed for inflation. Next year, it'll be $15.8 million. That means a married couple has to be worth more than $30 million before this tax is relevant. We have a few clients that are worth more than $30 million, but not many. And I bet there might be one or two people that secretly in this room are worth more than that, but not many. And so what does that mean? If you have complicated estate tax planning documents from the 90s or the early 2000s, where the wife has a trust and the husband has a trust, they called them AB trusts, you're probably overplanned. How did those old trusts work? Well, what happened was at the first death, half of the estate would go into the trust of the first spouse to die, and it would sit there for the benefit of the survivor until the second spouse died. And the reasoning behind that, back to 1998, was so instead of $640,000, you got to $1.2 million before the 55% tax. Well, two things have changed dramatically since then. Number one, as I mentioned, the exemption has gone so high that most people don't have to worry about it anyway. Number two, in 2011, Congress passed what's called portability, P-O-R-T ability, portability to transfer, so that a spouse can transfer the exemption from the first spouse to die to herself without the cumbersome two-trust process. That means those old AB trusts are out of date, and they're not good for two reasons. And by the way, my grandmother, Kerr, experienced, and her estate experienced all of this. My mother's father, my maternal grandfather, died at the age of 72 in 1997. My grandmother lived for another 21 years and was mad at her husband for dying that entire 21 years because he hadn't retired yet. They had all these plans to go on all these trips and it didn't happen. She was just downright upset at him. And back in 1997, that, their estate was worth more than $600,000. My grandfather was a successful businessman in Pennsylvania, but not a lot more than that. And that was a big estate 25 years ago, 30 years ago. So what happened? Half of the estate went into my grandfather's trust. Then my grandmother lived another 21 years, and then she passed away in 2018 when the exemption was $10 million. She didn't have anywhere near $10 million. But what were two bad things about that? Every year for 21 years, both an attorney and an accountant charged fees as it related to my grandfather's trust, which ended up being completely unnecessary. And worse than that, all of her assets at the end were in the stock market. Half were in a trust with a 1997 basis. Half were in a trust with a 2018 basis. She only got a step up in basis for capital gains purposes on half the assets. Huge mistake. What are capital gains? Capital gains are those taxes that we pay when we sell an appreciated asset, whether that be a Nebraska farm or a stock portfolio that has gone up in value since we bought it or inherited it or invested in it. Current capital gains rates are 21%. So my grandmother lost 21% of, well, not my grandmother, my mom and her two sisters, lost 21% of half of my grandmother's estate unnecessarily because they had these old A, B trusts where half were in the husband's trust, half were in the wife's trust. If you have that type of a trust, you are probably overplanned. If your spouse has died, you can fix it before the second spouse dies. It takes some work, but it's probably worth it if the assets are to be sold. Now, I work with hundreds of farm families, and half of farm families I work with are never going to sell the land. That's my wife's family from Hooper, Nebraska, where Steve's from. So Hooper, Nebraska, north of Fremont, home of Jordan Larson, go Big Red. My wife's father and brother farmed together. That farm's been in their family since 1903, and they are not selling it because I've got a nephew who's going to be a sixth generation Nebraska farmer, which is really cool. So capital gains are not a big deal unless you sell something. But if you're going to sell that farm after somebody dies, or you're going to be bought out, let's say the on-farm child is buying out his sister, there's going to be a tax event. So careful consideration needs to be given to capital gains. This is just the best example I can give you why if you haven't looked at your estate plan in 20 years, you're probably out of date. All right, I saw some eyes glazing over when I talked about 30 million. Let's get back to things that impact everybody, all right? Let's talk about number 7, forgetting about your things and stuff. You know, our biggest challenge after both parents die is dividing up their things and stuff at home. Even in a family where the kids get along, it's hard to divide up personal property, especially if mom and dad lived in the same home for 30 or 40 years. We collect a lot of stuff. Who gets mom's wedding ring? Who gets dad's favorite shotgun, to use the top 2 examples of sentimental value, jewelry and firearms. Other examples are artwork, family heirlooms, furniture, things that particular people want. How we handle this in estates is head on. In the estate planning process, every client gets a laundry list. It's a memorandum attached to the will or trust where you can say who gets items of personal property. Now, our best advice is to ask your kids or your nieces or nephews if there's something that they want. Spoiler alert, they don't want anything. Kids really don't want anything from their parents anymore. And I know you think it's a shame that they don't want your grandmother's china, but they don't. But there might be things that have high sentimental value that they want. And our biggest flashpoint are 2 people wanting the same thing. The biggest problem is if one of those people is an outlaw, you know, your daughter-in-law or your son-in-law who shouldn't even be in the room when they're dividing up the stuff and cause all the problems. It's true. And so what we want to avoid are 2 people wanting the same thing. And if you can take care of that during lifetime, that's the way to go. How? By giving it to them now. And you get to see them enjoy receiving it. Now, if it's something like your wedding ring that we're not going to part with until you pass away, the second best thing is to put it on a list with enough specificity that people know exactly what you're talking about. Jewelry is the number 1 thing we see on here. And I got a lot of kids who are like, I don't know which ring mom was talking about. So maybe take a picture, make sure that your kids know what you're talking about, and then you can specify those items. Most lawyers in Nebraska use these laundry lists. They're pretty common practice. Most clients don't fill them out. But my biggest takeaway here on mistakes is it's important for you to know that there's 3 types of property that legally should not go on the laundry list. In other words, if you put one of these, I call them the big 3, on a laundry list and someone objects, that person objecting will win no matter what, force the sale and get some of the money. These are unique assets that need to be handled carefully. Unique asset number 1, real property, real estate. Your house, your rental property, your farm. It does not work on a laundry list to say, my daughter gets farm A, my son gets farm B, love mom. If your son doesn't like the farm that you gave him, he can object, force the sale of both, and get half the money. Be careful with real estate. It's a unique asset, requires a legal description with a deed that's filed in the county where the real estate's located. Unique asset number 2, anything else that it takes a title to own. Car, boat, trailer, truck. These things have titles too. Since 2008 in Nebraska, it's pretty cool. We can put transfer on death right on the title itself. So you can go down to your favorite place, the DMV, go early in the month and early in the day. But they're actually getting kind of better, don't you think? I do. They got that concierge and all that. But you can go down and say, hi, I would like the People's City Mission. Pastor Tom loves to get cars. Or Nebraska Public Media. They talk about it all the time. To have my vehicle when I die. Or maybe you have that favorite grandson that you want to have your vehicle. I see a lot of grandkids get grandpa's truck. But that's something that you can do on your own. But you should not put those titled assets on a laundry list because technically they cannot transfer. Now, I'm a city kid and I work with hundreds of farmers, and I think it's hilarious that we can put a combine and a tractor worth $1 million on a laundry list because there's no title. I love that. So we'll put agricultural equipment, irrigation equipment, the tractor, the combine right on the laundry list, and that works because there's no title, but it doesn't work for your $4,000 pickup truck, okay? The third thing that cannot go on a laundry list, and this catches the most people unaware, is money or any form that U.S. currency takes. Coin collections, all the silver and gold bars that you have at home that you didn't tell your lawyer about. I know, it happens a lot. They're usually in the safe deposit box. So that is currency, and it does not work to put it on a laundry list. I'll give you 2 examples from my practice in recent years. Sorry, I'm going to get a sip of water here. So example number 1, I had a client who listed on the laundry list, all the contents of my safe deposit box go only to my daughter. What was in the safe deposit box? Gold bars. That didn't work. In his trust, everything was divided 50-50. So that failed, and those gold bars were divided 50-50 between the kids. Example number 2, I had a client pass away, lovely widow, who on her laundry list wrote on the list $10,000 to her church. She passed away, and her daughters, well, they didn't like mom's church because of politics. And so they asked me, do we have to honor mom's request and give the church that $10,000? And I said, well, to the daughters, I said, there's 2 answers to that. There's the moral answer and there's the legal answer. Now, the legal answer is no, you don't have to because that's not a proper transfer. Now, the moral answer, although it does not line up with my Reformed theology, is if you do not do what your mom wanted, she will come back and haunt you. And I do believe that will happen. But they didn't care about my little sermon. And so, yep, they sure enough, they did not leave the money to the church, which I still, as you can tell, am kind of mad about. And so be careful with personal property. It's a unique asset. And it's such a big deal that I'll pause there and see if there's any questions about things and stuff that you have around the house or personal property. Okey doke. All right, moving right along to mistake number 6. This is yes, sir.
Okay, talking about the donation, your $10,000 to the church. What's the?
That's a will. Do you want that done? Your family said they don't do it.
So I believe the question is, okay, I do want to leave $10,000 to my church. What's the best way? Is that your question, sir?
Yes.
Your will. Your family say no.
Okay, so it's a 2-part question, I think, and that's okay. I can handle it. What's the best way to do a charitable gift to a church? And if it's in your will, does your family have to honor it? Did I get it right? Okay, so I'll take the second part first. If the $10,000 gift is in your will, your family must honor it. That was my point, is that it should go in a will or a trust, or better yet, which I'm going to hijack your question and talk about an even better way to do charitable giving through your IRAs. I'll talk about that next. But if it's in your will or your trust, or an IRA designation, that is legally enforceable. My point in this subject matter was if you just wrote that on a list, signed and dated it, that's attached to your will, then it's not enforceable. So it needs to be enforceable. And so I'm pivoting to the first question, what's the best way to give money to my church? Well, a preacher's kid's going to take that one for sure, okay? I'm a strong believer in planned giving for charitable organizations. And these rules have changed dramatically since 2020. So most of you in the room have an individual retirement account, a traditional retirement account that you have to take required minimum distributions out of after you turn age now 73. For me and Carla, it'll be 74. So what does that mean? That means it's a tax deferred account. For most of us in town, it's our largest asset when we die. Not for a business owner or a farmer, but for most folks in town, that 401k traditional IRA is your largest asset when you die. House is usually the second. And so those are tax deferred. What that means is you never paid income taxes on that money. That meant you could take this amount, and it was this amount because you didn't pay taxes on it, and it grew even larger. The public policy behind these accounts is to sustain you in your retirement. And those retirement accounts are great until two times. The first is the required minimum distributions, when you have to take the money out and pay the taxes. Most in this room are familiar with that. When the first spouse dies, if you have your spouse named as the primary beneficiary, which you should almost always do, a spouse can do a tax-free rollover, which is great because there's no penalty or taxes. But the second time when an IRA is not great is after both mom and dad die. Why is that? Because of the Secure Act. So in February of 2020, right before the pandemic, so it's not well understood or well known, Congress changed the rules on retirement accounts. You see, prior to 2020, you could do what was called a stretch IRA. And if you inherited an IRA prior to January 1, 2020, you're grandfathered in. Don't worry about it. But for deaths January 1, 2020 moving forward, when your child or your niece and nephew receives your IRA, there is an ordinary income tax event at that moment. I am often the bearer of bad news to a successful doctor-daughter who says when she comes to meet with me, Andrew, can you believe it? Mom had $2 million in an IRA that she inherited from dad when he died. And can you believe I'm getting $2 million? And I say to my friend, the doctor-daughter, not really, because you pay income taxes at 37%. So you're going to lose $700,000 to $800,000 in income taxes. That's what happens, folks. That's when the piper is paid. The only thing she can do is pay it over 10 years. That's it. We don't have other options anymore. We used to, they're all gone. So, and a lot of people don't know about this. I always say, don't shoot the messenger. Talk to Mitt Romney. It was his idea. He was the sponsor of the legislation. So the only way you can do anything about that is to give it to charity. So what's my point here? I took a long, winding road to answer your question. My point is, if you want to leave a gift to your favorite charitable organization, whether that's your church or otherwise, it's no longer the best idea to do it through your will. Why? Because your will probably controls where your house goes, or your car goes, or your checking account goes. Guess what? Your kids are not going to pay income taxes on any of those items because they get that step up in basis that I was talking about. So if you're leaving your charitable gift through your will and your IRAs are going to your kids, you've got it backwards. So this is something to reevaluate, because if you leave 10% of your $1 million IRA to the Sheridan Lutheran Foundation, the Sheridan Lutheran Foundation gets a check for $100,000 because no taxes come out of it because it's a qualified charitable organization, whereas your daughter will, if she makes good money, is going to lose a fourth to a third of it in income taxes. So leave your children assets through the will or trust, leave your charitable organizations assets through your traditional retirement accounts or an annuity if it has tax consequences. So that's the new way of thinking in charitable giving. I'm sorry to hijack your question, but not really, because I always like to talk about that. Did I answer your question?
Yes.
Okay, great. Cool. Where was I? All right. I love that. Thank you. Mistake number 6, failing to plan for special needs. Is there a special person in your life, someone who's dependent on the government for their support? If that's the case, please don't make the mistake of leaving them a lot of money when you die outright. You may have only disqualified them from receiving government benefits. The better way is to leave assets in what's called a special needs trust, which serves as a supplement to what they'll receive otherwise. And I don't see the mistake made at the first line level. I work with a lot of parents of special needs children. They know what's going on. They've got it figured out. It's grandma and grandpa and aunt and great uncle who make the mistake. Why? Because in a standard will or trust, it says something like this: everything goes equally to my children, but God forbid if one of my children dies before me, their share goes down to their kids, my grandkids. We call that per stirpes. Sounds weird. It's Latin for lineal descendants. That works just fine and good if all of your kids survive you. But what if the mother of your special needs grandchild, I had this one recently, dies before you, and you can't change your plan because you have Alzheimer's? That's a situation we encountered in our office. A significant estate. Grandma had last done her estate planning in 1972. I was not her lawyer because that's the year I was born. And so what happened was her daughter died. Her grandson, who's my age, had special needs, but when her daughter died, grandma didn't know her own name. She was not able to sign a new document. We knew that we were going to have problems, so we were ready to go after grandma died. We went to court, spent thousands of dollars in attorney's fees to save the benefits of the grandson, and that's okay until he dies. But then guess what? All the money that was then in a special court trust for him has to go to the government to reimburse the government for his care. What grandma should have done is a special needs trust in her documents that said the money was for her grandson. And then when he died, the money does not go to the government. It goes to the charity of her choice, maybe one that helps her grandson's affliction, maybe to other family members. And so be careful, especially with contingent beneficiaries. Mistake number 5 is the number one question I get from new clients. How do I avoid probate? Well, what is probate? Probate is the old-fashioned process whereby a will is admitted to court. The judge appoints the executor, what we call a personal representative in Nebraska, and the estate is collected through the court system and distributed. Now, I joke with my clients, you'll never be worried about your own probate, ha ha, because you're dead. It's true. You won't be worried about your own probate. But your surviving spouse or your children or nieces and nephews will not like probate for 3 reasons. Reason number 1, attorney's fees. Lawyers charge handsomely for probate. Some lawyers charge more handsomely than others. In our practice, we only charge on an hourly rate basis. Truth be told, that's why we work with so many farm families, because we do not charge as most lawyers do, which is a percentage of the value of the estate. And with where land values are, as I mentioned earlier, our fees are literally sometimes 20 or 30 times less than a percentage fee. But even the way that we charge is expensive. And so if you avoid probate, you avoid significant attorney's fees. There are 2 other reasons to avoid probate, the court system. Number 2 is public record. Probate's a matter of public record. The will, and worse than that, an inventory of your assets and the fair market values admitted to court. Now, it used to be in the old days that a nosy person could go down to the courthouse, check out the file, read all about it. And believe me, they did. They did. I have clients who's told me that was their hobby 20 years ago. Now you don't have to do that because it's all online. Just like you can look up what your house is worth on Interlink and what your neighbor's house is assessed at, it's the same program. You can go in and say, oh, that's what Mrs. Miller's will said. Oh, wow, she was worth that much. If you're a more private person, you would prefer a trust because the only people that know your business are your beneficiaries and your trustee or personal representative, which might just be your 2 children. And that's the only people that know anything about your business. And a lot of our clients are very private people. The final reason that probate's not good, and this is the big one, is it takes too long. On average, probate lasts 9 to 12 months. Drives kids nuts. They say, oh, come on. The will says that the house goes to my sister and me. Why do we have to go through probate? And I say to my friend from Lincoln East, who now lives in California, whose mom just died, and all the cash assets had already transferred to the kids except the house in Colonial Hills. I say, well, because in Nebraska, if the house is worth more than $100,000, which every single house in Lincoln, Nebraska is worth more than $100,000, then we have to go through the dog and pony show of the court system. So most of our clients wish to avoid probate. It's a good goal. How do you do it? There's 100 ways to avoid probate. A beneficiary designation avoids probate. A trust is the most common vehicle. A trust is a document, kind of like an LLC, that you create during your lifetime. I call it a bucket that you put assets into so that after you die, your trustee, what we call the executor with the trust, can just automatically pay your bills and distribute assets without going mother may I to our probate judge, who's a wonderful person. Her name is Holly Parsley. She was a year ahead of me in law school and a friend of mine. And I always joke with Holly, we have one dedicated probate judge in Lancaster County, and she is busier than she can keep up with. You read the obituaries because so many people are dying, and most estates go run through her courtroom on Wednesday mornings. That's when probate court is. That's the only day of the week I have to wear a tie because she still requires a tie. And she always says, all your clients want to avoid me, Andrew. I'm like, yeah, they do. But the probate process is to be avoided. My biggest takeaway on trusts is if you already have a trust, most people use trusts. So if you already have a trust, is it funded correctly? F-U-N-D-E-D, funded. That's the term that lawyers and financial advisors use. Because if you just signed a trust because you thought it was a good idea for taxes 20 years ago, but you bought a new home and your home is in your name alone, guess what? There's going to be a probate. That happens about 10% of the time when people have trusts. They forget that they have a trust and they go out and buy a new asset. Maybe it's a house in Arizona. And then the kids come in and they're like, hey, did mom tell you about that house she bought down in Arizona? No. And we had all of our assets in Nebraska in the trust. But guess what? We got to hire some lawyer in Scottsdale. And by the way, they know how to charge. They'll charge about $10,000 just to transfer a house in Scottsdale because we didn't get into the trust. So if you don't remember anything else that I say today, if you have a trust and you don't know whether it's funded, that's number one on your homework list today, is to go back to your lawyer, back to your financial advisor, back to your accountant and say, are we avoiding probate here? It might be as simple as a deed, to deed the house or farm to the trust. But if you don't do it before you die, it's going to be expensive, time consuming, and a matter of public record for your family. Mistake? Yes, sir.
If you have your will made out and everything's going to your spouse and then to your kids after that, what would that require probate just in itself?
The question is, if you have your will made out, that you have everything going to your spouse, and then if both spouses have died, that everything goes to your children, would that cause a probate? And the answer is, it depends. That's the lawyer's favorite answer to every question, because, then we have to research it and we can bill you for it, right? Okay. So it depends on what you own. So the quintessential example is a house. So if you own a house worth more than $100,000, yes, after both you and your spouse die, your children would have to go through the probate process. So that's the most common example of a probate, is a house. Because anymore, most people's financial assets transfer automatically through beneficiary designations. And so there's a couple of ways to skin that cat. We can use a trust. Another way, if it's just the house, is a transfer on death deed. Since 2008, we've had the ability to do a TOD deed. And it's pretty cool. It's got a few limitations, which I'll mention. A TOD deed is specific to that house. So if you own more than one house, you're going to want to use a trust because you can put all of those properties into the trust. And if you're about to move in a year or two to another house, you probably want to wait to do the TOD deed because you're going to have to do it again because it's specific to a piece of real estate. The other disadvantage, and it's a big thing lawyers worry about, is homeowners insurance expires 30 days after death with a transfer on death deed. So we get worried about the house fire that happens on day 31. The easy workaround on that is to add your children as additional insureds on your policy now, or impress upon them that when you die, they need to get homeowners insurance ASAP. But I'd rather that you take care of it before you pass away. But a lot of our clients are using transfer on death deeds. They're less expensive than a trust. They're easy. I mean, just to brass tax it, if I'm doing a trust-based estate plan for a family, it's usually around $3,000 for all the bells and whistles. We charge $400 for a transfer on death deed. It's simple, it's inexpensive. If the only asset that you have that would cause a probate is your house, it's something to think about. Yes, ma'am.
Does that change depending on where the house is located, what state?
Does the transfer on death analysis change depending on which state you're located in? And the answer is yes, because not every state has transfer on death deeds. I know Missouri does, because I was just talking to a client about this and I looked it up, but I'm only licensed in Nebraska. Go Big Red. So I have no plans of ever practicing anywhere else. So I can only work with people who are residents of Nebraska. So if you have plans to move to another state, you might want to investigate whether that state has a transfer on death deed. If they do not, let's say you're moving to a state that does not, Pennsylvania. I know, that's my home state. My dad's a minister. We moved here to Lincoln when I was 15 from Western Pennsylvania, and I stayed. My dad was the pastor at Eastridge Presbyterian Church from 1987 to 1999, and then ditched us and moved to Florida 26 years ago and served the church down there and is happily retired. But I know that in our home state of Pennsylvania, there's no such thing as a transfer on death deed. So if I was going to move home to Pennsylvania, I'm not. But if I was going to move home to Pennsylvania, I'd do a trust for sure, because then I'd buy the new house there in a trust.
So house and land should be in a trust.
So the question is, the house and land should be in a trust. Most of our clients who own real estate and want to avoid probate use a trust because it's versatile. You can move in and out of different assets, LLCs, farms, rental properties, all work super well with trusts. The exception to that would be the person who doesn't have any other assets other than a house and a retirement account. They could probably use a transfer on death deed. Yes, Gunter.
What is the mechanism for putting things into a trust?
What is the mechanism for putting things into a trust? Comes from an answer or a question online, right? Okay. Or was that from Gunter? Oh, that's from Gunter. Sorry. Okay. The mechanism depends on the asset. So I'll just use 3 different examples: a house, a car, and a checking account. So with a house, the mechanism is a deed to the trust. So it's a 1 or 2 page deed that says, now instead of me owning the house, it's my trust owns the house. That's really simple but important. Now let's talk about a car. You're going to hear different advice from different lawyers on vehicles, and that's okay. Different lawyers look at things differently. Some lawyers have their clients put the vehicle in the trust. We do not. We advise against that because we've learned the hard way that if your vehicle's in your trust and you are the negligent driver, I've had this happen to some clients, it's easier for the plaintiff's attorney to come after your other assets that are in the trust. So I would keep the car out of the trust and instead use that transfer on death mechanism that I described earlier, either to a specific person or charity, or if you're like most of our clients and say, nobody wants my car, just sell it and give it to the kids. Then we do transfer on death for the car to the trust so that it can be sold and the money split. Final example, a checking account. Again, you're going to hear different advice from different lawyers. Some lawyers like you to put that checking account into the trust now. I think it looks a little too fancy myself, so I don't like that. Oh, I have a trust. I prefer that you keep it the way that you have it and put pay on death, P-O-D, to the trust, so that when you die, automatically your money goes to your trust and your daughter has access to help pay for the funeral, which I know is what you're all concerned about, is after you die, who's going to pay for the funeral? I'm here to tell you, Tom Roper's my golf partner at Hillcrest Country Club. He's doing just fine. He can wait to be paid 30. He hates it when I say, I love it. I do it every time. He's like, you got to stop saying that. Nah, that's too good of a joke. Yes, sir. Just true though.
When a person has a checking account, they can add their siblings and everything to that account. And then, upon her death and everything, they're, no matter how many, 3, 4, 5 kids or something, are owners of that account. They can split it at that time. Is that correct?
That is correct. So this gentleman's point was, you can add an owner to a checking account. And if you add an owner to the checking account, let's say it's your 3 children become the co-owner of the account with you. Technically now they each own 1/4 of the account. And if you own it as joint tenants with rights of survivorship, when the first one of you dies, presumably dad, then that money is going to be owned by those kids. No questions asked. Is that true? The answer is yes. With the quick follow-up, our strong advice is never to do that. And here's why. It's a mistake because you have now subject all that money to your children's divorce, to their bankruptcy, and to their credit card problems. So when you make a child a co-owner of any asset, it is now technically theirs. And if that asset is an appreciated asset like your house, you've made a big mistake because they will not get a step up in basis for capital gains purposes on 3/4 of the house, to use your example. So you bought the house for $80,000 and it sells for $400,000. That's not an unusual example in Lincoln, Nebraska. And you put your 3 kids on the house, they will pay 21% income tax on 3/4 of the gain because they were technically the owners. The much better way is to do a transfer on death, a pay on death, or a trust. Avoid probate, allow the immediate access of the beneficiary to the asset, but avoid the exposure to those problems. Now I got to speed up. I apologize. I'll stick around, but we don't have any time left and I have 3 left. So I'm going to tell you number 3 is its own seminar. So Carla Fries is an expert in home care, health, and all the options for senior living and how to deal with long-term care issues. So I think what should happen is that you should invite Carla and I back to talk about Medicaid because it's an hour-long topic. There's a lot of material. We counsel families on the 5-year look-back period on Medicaid qualification. I'd be happy to co-present with Carla, who knows more about it than I do. One thing I will say is we're very blessed in Lincoln, Nebraska to have Aging Partners, which is a quasi-governmental agency that is in this space. So that's not a bad idea. If you have questions, visit our friends there. They're at Victory Park, where where the Veterans Hospital used to be, just north of the best high school in America, Lincoln East. Okay, sorry, I'm a proud alum. All right, so final 2 things real quick. Mistake number 2, I think I'm going to switch the list around because this is really mistake number 1. Naming the wrong person to be your executor. I can write the nicest looking will or trust for you, but if you name the wrong person to be your executor, it will not go well. Let me give you some examples. Is your daughter a procrastinator? Does your son have a drug and alcohol problem? Does your niece who lives in California never come to visit you and isn't really sure where Nebraska is? Do your 2 children not talk to each other because they voted for different people in the presidential election? These are all reasons not to name an individual as the personal representative or a trustee. We have clients increasingly whose children have not paid them back loans. I hear about it every week, and they're going to make things equal when they die. Please don't name your daughter who's getting more to deliver the bad news to her brother that because he stiffed mom for $100,000 that he's getting less than she is. You're going to ruin their relationship and just cause a fight. You won't be worried about it, but that's not a great thing to put a child in that position. Are you disinheriting a child? Do you have a child who has a drug and alcohol problem? Don't name their sibling to be the one in charge and be the bad guy. It's really a good idea in lots of situations to remove family dynamics and name an independent third party to be the trustee and the personal representative. We are blessed in Lincoln, Nebraska to have outstanding locally owned trust companies. This is what they do for their day job. They're highly competitive, so I'm going to mention them in no particular order. I like all of them equally. Union Bank and Trust Company, First Nebraska Trust Company. Those are the two Lincoln owned and based trust companies. So I guess I am a little biased towards them because I'm a Lincoln guy. But we also have Pinnacle Bank, which is out of Omaha, but it has a large Lincoln presence. All of these are family owned, Nebraska owned trust companies. They don't charge you while you're alive. What a deal. If you name them in your estate plan, there'll be a one-time charge after you pass away, removes all family dynamics, a trust officer who's trained to do this. It's their day job from 8 to 5, so they have the time to do it, gets everything done correctly, and you don't even give your kids a chance to fight. Yeah, I'm fond of saying UBT has estates done before I even knew my client was dead. It's efficient, quick and easy. There is a fee. It's usually about 1% of the estate. I was kind of elbowing attorneys who charge percentage fees, but I think this is different. I do not think it's appropriate for an attorney to charge a percentage fee because there's just frankly not that much work involved. If you name a corporate trust department, they do everything. They have in-house accountants, in-house lawyers. They'll send people to mow your lawn. And so it's well worth it in some estates to name that third party. And then another option is, all right, you have 3 kids. 1 is the logical person to name. 2, probably not. Why don't we name that one child first and back them up by First Nebraska Trust Company? So when the time comes, if that one child's experiencing a health problem themselves, or it's just a bad time of life for them, they can hand the baton off to a third party and they'll take care of business. You can tell I feel strongly about it. It's because our biggest frustration in our practice, our little law firm of 5 attorneys, all we do is estate planning. We don't do any other type of law. We don't go to court other than Judge Parsley. And our biggest frustration are children who are lousy trustees and personal representatives because they can't balance their own checkbook. They're just mean and taking it out on their sister. You name it, we see it. All right, final mistake, and this truly is the number one mistake. And this really is the thing. If you don't remember anything else that I say today, this is the biggie. Please double check your beneficiary designations. Remember that whomever you have listed as your beneficiary on your IRA, your life insurance, your annuity, your 401k, the pay on death on your CD, that is more powerful than your will or trust. In other words, it doesn't matter that your will says everything goes equally to your 3 kids if you have one child as the co-owner of the bank account or CD, because that one child will own all the money and be under no legal compulsion to use the money to pay your debts or expenses and to share with his brother or sister. Now, I do believe that you'll come back and haunt them if they do that, like I said, but legally it's a problem. And whomever's your beneficiary on your IRA, it doesn't matter. If one of your kids is the beneficiary on the IRA and you have in a will that it goes 3 ways, it just all goes to that one kid. So please go back and double check your beneficiary designations because as a matter of contract, they're more powerful than a will or trust. So those are my top 10 mistakes. Yes, sir.
I'm assuming that you only want one executor on your will.
Ooh, that's a good question. The question is, do you want one executor or more? Well, I always tell clients you've got 3 choices when it comes to who your executor is. You can name one person, you can name more than one person, or you can name an independent third party, as I was just talking about. Most people don't take me up on my advice naming an independent third party. Most people do name a child. So the question comes down to, is it 1 or 2 children? I can argue everything both ways. They teach us in law school to do that. So this is a pretty easy one for me to argue both ways. A benefit of having just one child is there's no disagreement. Now, the child has to follow out your instructions in the will, but 2 children who are co-executors can disagree. And you might say, well, what could they possibly disagree about? Everything. I'll give you an easy example. We're going to sell the house. Daughter says, we are using a realtor because my husband's the realtor. And brother says, we're never using a realtor. We're not going to pay the realtor that fee. Burn, 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 burn. 1 versus 1 is a tie. What are we going to do? Who's going to break the tie? If you have 3 kids and you name all 3, 1 beats 2 because you have to have all 3 sign off on it. And so if you have 2 children who get along famously, I think it's just fine to name both of them because they can share the responsibility. But does one live in Lincoln and one lives in Florida? Probably aren't going to share the responsibility equally. And it's kind of like that school project where everybody, 3 people worked on it, you did all the work and the other 2 got the credit. Kind of feels that way to the kid, usually the local child who did all the work. And it matters with fees too. Executors can charge a fee. In Nebraska, you can charge a percentage up to 1%, or what we recommend is you can charge an hourly rate. Judge Parsley likes to see about $40 to $50 an hour, unless it takes away from your day job where you make more. I just settled a large estate in York County where my executor is a solo practitioner doctor. And it was a very involved estate with farms and businesses. And he spent so much time on it, he made significantly less money because he couldn't see as many patients. So the court let him charge more than we would normally. But the fees become a lightning rod in an estate too. I was trained by my mentor in this area, Doug Deichler, who retired, I can't believe it, 16 years ago. He trained me to remind people of 2 things when you talk to a client about the fee for the executor. Number 1, no matter what you charge, Madam Executor, your brother's going to think it's too much because it's taking away from his inheritance. And that's true. And the other thing to keep in mind is it's taxable income. So when you take a fee, you got to report it on your 1040. So what a lot of families do is a little horse trading, especially families that get along. We'll get around the table and I'll mention that and like, oh, I don't like that. That might bump me into a different bracket. That'd be dumb. Yeah, that'd be dumb. So how about mom's car? Maybe mom's car just goes to the executor as her payment. I mean, that's just an example of things that we can do that sometimes make more sense. Yes, ma'am.
How difficult is it to add a trustee after the first died? 2 brothers were co-trustees and one is deceased. If you have a second party that needs to step in,
how difficult and expensive is it to amend my trust? And the answer is it shouldn't be very expensive at all. It will be less expensive if you go to the attorney who did the document, because presumably they have the document ready to go on their word process. Yes, ma'am.
Deceased. Yeah. The one sentence deceased. Which the 3rd sentence.
Gotcha. Okay. So I misunderstood the question. So the question is, mom and dad have died. And there were 2 trustees named on the trust, but one of them has died. What do we have to do to change who the trustee is? Well, if everyone's getting along, then you can just do an agreement amongst yourselves under the Uniform Trust Code. And it's since 2003, we've had a Uniform Trust Code in Nebraska, which is great. It allows us to do things like this without a whole lot of court involvement. And so if everybody agrees, we can just do some simple paperwork, hundreds of dollars, not thousands of dollars, that would help out. Where it gets expensive and dicey is if anyone disagrees, because the trustee is a material provision of the trust and cannot be changed without court action. If any one of the 5 beneficiaries says, nope, I don't agree, then you got to go to court. So, and usually it's not worth it when you think about the amount of fees involved. And our laws are very pro-trustee, and the trustee can use the trust's assets for his attorney's fees, and the beneficiaries have to use their assets for their attorney's fees. We don't do litigated matters. We're really good referral sources for that. Other lawyers really like me. I send them lots of business because we don't touch it, because we just do the happy stuff. But it can get expensive real quick. Did that answer your question? Okay. Yes, ma'am.
If you have a 3rd party trustee and let's say that there's been liens in failure or real estate asset, can the trustee, the 3rd party trustee, just go ahead and sell that to whomever they want, wherever they want, even against the wishes of one or more family members?
So the question is, you've got a 3rd party trustee and this trust has land in it, real estate. Can the 3rd party trustee just sell the real estate regardless of what the beneficiaries say? And that depends on how the trust is written. So in lots of trust documents, we will say that the children have a first right of refusal or an option to purchase the ground at favorable rates. This is very common given how high land prices are. So a typical example would be, we are going to sell it, but any one of my children can be the purchaser. And if one of my kids wants to be the purchaser, they only have to pay at the assessed value, not the fair market value. Sometimes we say the assessed value with a 20% haircut or discount, and that they can pay it over 7 or 10 years to make it more affordable. A very common technique, but that's got to be in the trust. And the trust also might say the trustee has the power to sell. That would be in the trust, or it might say the opposite. It might say the trustee must distribute land in kind. And so the devil is in the details there. So it depends how the trust is written. Big time. Yes, sir.
Stock question. It was stock with my mother-in-law for years and years. Well, the son needs a kid because he's moved into the house. Deceased. That, the jewelry, that's all he didn't have to. Just a mess. Why is someone to do?
Yeah, the question, and it's a real troublesome issue, is when an adult child moves in with a parent before the parent dies, and then the parent dies. You know, who owns the house? Who owns the jewelry? Who owns the Walmart stock that went way up? Well, the legal answer is, with the real estate, it's who's on the deed. So even if he lived there, if he's not on the deed to the house, he doesn't own it. So it's the will or the trust, or if mom didn't have a will, Nebraska law that controls who owns it, not him. Same with the jewelry.
He could look for somebody to try and help him.
Excuse me?
He could try to get that changed so his name is on it.
Not if mom's dead. So his response was, well, the son who's moved in could try to get that changed. I thought that the parent had died in your example.
Yeah.
If the parent had died, then he absolutely cannot get it changed because it's too late. If the parent's still alive, he's the person doing the undue influencing that I talked about earlier. And that leads to lots of lawsuits. But as far as jewelry goes, and it's a biggie, the will controls it. But I think it was the first day of law school that we were taught possession is 9/10 of the law. And you and I both know there's no way you're going to know what he took out of the house and have no way of proving it unless you got a camera in there. And then as it relates to the stock, the Walmart stock, it's also controlled by the will unless many stocks have transfer on death on them. So there might be a transfer on death registry with Walmart you want to check out. The good news with the house, jewelry, and the stock is it all gets a step up in basis. So all the capital gains goes away. The bad news with the kid who's living in the house after his parent died is he's a squatter. And squatters have rights. In Nebraska, a squatter has way more rights than a tenant. I would prefer that the son had signed a lease because it'll take us about 9 to, or 3 to 6 months, but we can get him out of there. If mom just let him live there for free, he's probably there for a year at least because you got to sue him. He's got the right to stay there. Believe me, we've had squatters in 6 or 8 years. Wow. Yeah, not good. So if your adult child comes home to live with you, seriously, have them sign a lease so your executor can kick them out within 3 months. It may seem strange to you, but it really happens. So, yes, sir.
I know real estate transfers changed over the years. It used to be that you had to pay taxes on any capital gains. So now you get kind of a stepped up basis that you talked about. Is there a limit on how much of this, you talked about 80,000, now we're at 400,000. So is there a limit on how much capital gains is for free and then you have to start paying?
So the question is, can you explain a little bit about how capital gains works currently and any limits on it? Well, at death, which is my world, it's unlimited. There used to be limits, but it's not. You can have $20 million and you can give all that away at death. It might be subject to the estate tax because 15 million it wasn't and 5 million subject to it, but all of the capital gains get wiped out in a thing like a farm or an LLC or a rental property or your house. That's at death. During lifetime with real estate, there's only two ways to not pay capital gains. The first is unique to your personal residence, and you can only have one personal residence. I know a lot of people have more than one house, but only one is your residence. And if you've lived in that residence for 2 out of the last 5 years, don't ask me where they come up with these rules, I don't know, then you have a $250,000 exemption from capital gains. Where I've seen this catch a lot of folks recently was a widow. So let's say a married couple bought a house in the 1970s for $30,000, and today it's worth $400,000. Well, if the married couple sold the house together with their $250,000, they've got $500,000 worth of exemption, no problem. But if the husband died, we've only got $250,000 of exemption. So now we've got exposure to capital gains. So that's been a problem for a lot of my widow and widower clients who didn't know that and didn't sell the house till after the first spouse died. So that's something to think about. The other way to not pay capital gains is to do what's called a 1031 exchange. Now, I do not handle those, although I know enough to be dangerous. That's where you sell the real estate, we'll call it a farm, and you don't take the money, but you reinvest it within 6 months in other real estate. It can be anything. It can be rental properties, another farm, a commercial building in Chicago, a real estate investment trust that owns 400 different properties around the country, all kinds of cool things you can do to delay the income tax. So in law school in this space, they teach us to delay, exchange, die. You know, that last part's not a great part of the strategy, but it does work because of the unlimited step up in basis. So that's what we do, counsel people to do is exchange, die, wipe out the capital gains, sell it, and it's like it's Christmas. So.
That's one sub question.
Of course.
15 and 30 million, is that, well, single or married couples, you know, 2 people, will, what was my question gonna be? Will, I'll go to someone else and maybe I'll even.
Okay, no problem. Yeah, well, the 50, just so to kind of follow up, the 15 and the 30 relate to the death tax, not capital gains. So it's a separate but related issue.
Is that federal and state, or just federal?
So the question is that 15 or 30 million federal or federal and state? It's just federal. So that might be a good place for us to end because I'm over my time. But since you asked about it, I'll talk about our super annoying Nebraska inheritance tax. Okay, it's a bit embarrassing. We're one of 4 states left that has an inheritance tax. 46 states have gotten wise and gotten rid of theirs. The last was Iowa. They got rid of it 2 years ago. But here in Nebraska, we've got to be unique. You know, we've got the only one-house legislature. We divide our electoral votes differently. Some of these things are cool. This one's not so cool. We also have an inheritance tax at the county level. We're the only state that's ever done it. So the only reason Nebraska still has an inheritance tax is because the money does not go to the state. It goes to the 93 counties and they won't give it up. So if you have a friend who's a county commissioner, by the way, I've given this talk several times when there's a county commissioner in the room and I got a talking to afterwards. So if there's a county commissioner in the room, I respectfully disagree with your position. But I don't like the tax because it punishes people who do not have children. So this is the other way that we are unique. No other state ever did it this way. We tax people in Nebraska on how you're related to the person who died. So a spouse pays 0 tax. So when the first spouse dies, families don't notice anything because if everything goes to mom, she doesn't pay inheritance tax. It's at the second death that there's a tax. Children and grandchildren get the first $100,000 tax free, and then it's 1% after that. So if you have $1 million estate and 3 kids, the first $300,000 is tax free. And then 1% of 700,000, $7,000 goes to Lancaster County. It's due within 1 year of your death. If you own a farm in Dodge County, where my wife's from, then it's apportioned and that money goes to Fremont and the rest goes to Lincoln. That's how it works with the counties. But where this tax is regressive, in my opinion, is the next two categories. I have a lot of clients who do not have children. They tend to leave their estate to their nieces and nephews, and we really hammer them with taxes. A niece or nephew only gets the first $40,000 tax-free, and then ouch, an 11% tax after that. Last year, our office sent a check to Lancaster County for $720,000 because a client of mine received an inheritance from her uncle. I know her uncle probably didn't even know about this. He wasn't my client. He just did a simple will, left everything to his niece. It was a large estate because he never had kids, saved lots of money. And 11% of the large estate was $720,000. If it had been his daughter, it would have been 70,000. So, I mean, it's regressive. It gets worse. If you leave money to someone to whom you are not related at all, and in Nebraska, we do not have common law marriage. If you've lived with somebody for 30 years, you're not married. Across the river in Iowa, they do have common law marriage. If you've lived with somebody as your spouse for 7 years, legally they become your spouse. Not so in Nebraska. So unless you said I do, that other person gets the first $25,000 tax-free, and then ouch, 13% goes to the county. Now, a couple of things about that. There are two assets that are not taxed by inheritance tax. Number one, life insurance. Why? I don't know. They must have good lobbyists. That's all I can come up with. The other thing is real estate in another state. So you inherited a farm in Kansas, that will not be taxed by the Nebraska inheritance tax. But everything else, all of your investments, all your retirement accounts, all your real estate in Nebraska is taxed, and children pay 1%. It's annoying, but it's really regressive and high if it's a niece or nephew. Oh, by the way, charities do not pay inheritance tax. So if you leave it to the Sheridan Lutheran Foundation, zero inheritance tax. Okay, thanks for inviting me back. I'll come back and talk about Medicaid with Carla sometime. How about that? Gives it me up. Thanks. Oh, I'll turn it off. Sorry. Probably screwed up. Now it's. I just instinctively turned it off. I apologize. Did I use all the batteries? Oh, no. I messed up the mic. Sorry.
Well, let's thank Andrew one more time. And, we really won't work.
Now it really not.
We have
Or maybe it will.
few speakers that volunteer to come back right away.
I do.
So we appreciate that. A couple of announcements. I hope all of you looked at your email. I sent up.
Stand in front of the camera, please.
Pardon me. Oh.
Mhm.
I sent an email regarding a talk by Dr. Ray Dorsey. It's very good. I hope you'll take the time to listen to it. It's about 35 minutes long, I think. Also, several attended the governor's signing of our proclamation over here near the library at that thing that I've dropped down a few times and made lots of noise. Is a thing in a blue folder if you would like to look at the proclamation. And are there any other announcements that, have you read anything, heard anything that you want to share? Next month, on May 24th, Jenna Wilker, she's a nutrition. She's been here before. She's going to come back again and talk about nutrition as it relates to Parkinson's. She's been very good when we've heard her speak at symposium. Been very good when she came and joined us here. So she's with the UNMC, and I think we'll be Whoa.
Oh, good.
Can you hear it? Yeah. Hey, yay. So that's what we look forward to next month. There, any other comments? Like, again, thank Andrew, I want to thank Gunter for doing the Zoom, and Jim for doing the library, and Sally for holding up the proclamation. And,
It's heavy.
and Sally for the refreshments. Remember, we also have brochures and business cards that we would like to share. It's still, the number of people in the United States that are diagnosed with Parkinson's is gone up from 600 to 60,000 to 90,000. I mean, it's phenomenal. And we need to spread the word that there are education opportunities so that we can learn more about what's going on. Now is the time that those with Parkinson's can stay in this room, pick up a refreshment, and those care partners to the kitchen, but bring your food with you. Okay, I hope to see you all next month. Thank you.